So today's video is about history of courts, starting with module 1, 1.1.1 as per the Mumbai University syllabus. Let us look at the period from 1600 to 1726. Let's begin with our first topic. The topic name is period from 1600 to 1726. This is the early phase of British administration of justice in India. Let's look at the historical background first. The period from 1600 to 1726 marked the initial phase of British judicial administration in India. This era begins with the incorporation of the English East India Company and extends up to the establishment of mayors' courts by the Charter of 1726. So basically, the mayor court was established by the Charter of 1726, and the period of 1600 to 1726 marked the initial phase of British judicial administration in India. The company's early objective was trade, not governance. However, with growing settlements, disputes among Englishmen and between English and Indians arose, creating the need for judicial system. Second, the English East India Company and its legal authority. The East India Company was established on December 31st, 1600 by a charter granted by Queen Elizabeth I. The charter granted the company a monopoly over trade with the East Indies for 15 years. The company was given power to make reasonable laws, ordinances and punishments for its employees, provided they were consistent with the laws of England. Key points: these powers were corporate, not territorial, meaning the company could govern its own people but not local inhabitants of India. Third, establishment of trading factories and early judicial arrangements. Between 1611 and 1620, the company established factories at Surat, Madras, Bombay and Calcutta. These were the trading posts under the local rulers of those areas. Initially, disputes were settled by company officials or agents applying English law informally among Englishmen, and native law and customs were applied to Indians by their own community leaders. For example, in Surat, 1612 onwards, the first English factory was set up in Surat. The local Mughal governor, Subedar, retained judicial control. English disputes were handled by company agents. In Madras, Fort St. George from 1639, granted by a local ruler to the company, the governor and council exercised judicial and executive power there. They acted as judges in both civil and criminal matters among English residents. Native inhabitants were governed by their own laws and customs. In Bombay, 1668, the Bombay was acquired by England as part of Catherine of Braganza's dowry when she married Charles II of England in 1661. In 1668, Charles II leased Bombay to the East India Company for £10 per annum. The governor and council in Bombay were authorized to make laws, administer justice and appoint judges. In Calcutta, 1690 onwards, Job Charnock established a factory in 1690. By 1698, Calcutta, Sutanuti, Govindpur and Calicut was officially acquired. A governor and council was appointed for Fort William. The administration of justice was rudimentary. Company officials decided disputes informally. So we see that at 4 different locations, different kind of administration and the judicial administration was taking place. For example, in Surat, where the first factory was set up, there the judicial control was under the local Mughal governor, who was also known as Subedar, and the disputes among the Englishmen were handled by the company agents in Surat. Whereas in Madras, at Fort St. George, that area was granted by a local ruler to the company, and therefore the governor and council exercised judicial and executive powers in that locality. They acted as judges in both civil and criminal matters for the English residents, but native inhabitants were still governed by their own laws and customs. In 1668, we see that the governor and council, where it was same for Madras, in Bombay also, the governor and council were authorized to make law, administer justice and appoint judges as well. Whereas in Calcutta was also officially acquired by 1698. The factories were set up in all the 4 locations. There too, governor and council was appointed. They were in charge of the administration of justice, but it was very rudimentary, very basic. Company officials decided disputes among themselves informally. So this is how the administration of justice took place in these 4 settlements or 4 locations or 4 trading factories acquired by the British East India Company. This was between 1611 and 1620, where all these factories were acquired, or where these factories were set up. Next is the charters and evolution of judicial power. The Charter of 1661, issued by Charles II, was a turning point in company's governance. Granted to the company, and this charter granted the company the power to make laws, administer justice, and impose punishment on English subjects residing in India. The governor and council in each settlement could try both civil and criminal cases. So we had Surat, then we had Madras, Bombay and Calcutta. So except for Surat, Bombay, Madras and Calcutta, there the governor and council were the judicial authorities who administered justice in both civil and criminal matters. So they were granted by the Charter of 1661 to make laws, administer justice and impose punishment on the English subjects residing in India. And they could also try both civil and criminal cases in each of these settlements. The courts which were in practice at that time were governor and council. This was the main judicial authority. Minor officers handled petty cases. Appeals could be made to the courts of directors in England. So the main authority, main court was of the governor and council, and the petty cases, small cases were handled by the minor officers, and appeals went to court of directors in England. Limitations and problems during this period of 1600 to 1726. There was no separation of powers. Executive and judicial functions overlapped. The justice was arbitrary, that is, governors were also merchants, they were not trained judges. There was a lack of uniformity, which meant that different practices in each settlement, that is, each settlement used to have different practices of judicial administration. Indians often received unequal or minimal justice under the company's rule. So these were the main limitation and problems during this period of 1600 to 1726. That is, there was no separation of powers, the justice was arbitrary, there was a lack of uniformity, and unequal or minimal justice for the Indians under the company's rules. This is just before the start of 1726. What happened? There was a lot of chaos and inconsistency across different settlements, which led to the intervention of the British Crown. The Charter of 1726 was issued by King George I to establish mayors' courts in Bombay, Madras and Calcutta. The first time King George I, through Charter of 1726, established mayors' courts in Bombay, Madras and Calcutta. These mayors' courts were created for a more uniform and formal judicial system. And this marked the end of the unregulated phase of 1600 to 1726 and the beginning of the structured colonial courts in India. Now let us look at the condensed summary of the above text. So period was between 1600 to 1726. The starting point was by Queen Elizabeth I through the Charter of 1600, granting East India Company a period of 15 years, a lease of 15 years. The end was by George I through a Charter of 1726, where the orders were issued to establish mayor's courts in the three constituencies or presidencies or the settlements of the East India Company, that was Bombay, Madras and Calcutta. Company rule as traders, not sovereigns. So the company was set up for trading, and the application of the judicial system was more based on the traders. These were mostly traders and not judges. The main settlements were Surat, Madras, Bombay and Calcutta. The judicial authority were governor and council who administered justice. In 1661, Charles II issued the first legal recognition of the company's judicial power through 1661 Charter. There were a lot of limitations during this period. Justice was arbitrary. It lacked trained judges. And there was no uniformity in the way the justice was delivered in the different presidencies. It laid the most significant aspect of this during this period was that finally it laid the foundation for formal courts under the 1726 Charter. Okay, let us look at few question answers, try to answer these questions. So what was the main purpose of East India Company when it was established in 1600? So the main purpose of the East India Company when it was established in 1600 was to trade, and it was mostly for trading purpose. The East India Company established in 1600 was mostly for trading purpose. Explain the significance of the Charter of 1661. Through the Charter of 1661, King George I gave the authority. We have the here. Answer is here. It was the first legal recognition of the company's judicial power through 1661 Charter. First legal recognition of company's judicial powers. How was justice administered in Madras before 1720? Before 1726, the justice was very rudimentary in nature. The governor in council were the main judicial administrators, and the local and the English officers, the officers of the company were under the jurisdiction of the governor in council. And how was justice administered in Madras before 1726? Let's look for the. So we'll have to look at the limitations. Before 1726, there was no separation of powers. The executive and the judicial functions overlapped. The justice was very arbitrary. Governors were merchant, not trained judges, and they lacked uniformity. That is, different practices were conducted in each of these settlements. Indians often received unequal or minimal justice under the company's rules. So this is how the justice was administered in Madras before 1720. The another answer could be also that company officials or agents applied English law among the Englishmen, and native law and customs applied to Indians by their own community leaders. This can also be an answer. What were the main problems in the judicial system during this problem? So we already covered this in the previous question. The answer is that there was arbitrariness in the way the justice was delivered. Let us go through the revisions again. There was no separation of powers. That is, both the executive and judicial functions overlapped. There was lack of uniformity. That is, different settlements practiced. They had different practices in the way the justice was administered. And of course, Indians were treated unequally and under the company's rule. Which cities were included under the Charter of 1726? So under the Charter of 1726, three cities or three presidencies were included, which was Bombay, Madras and Calcutta. Now let us look at little longer answers for essay questions. Trace the development of judicial administration in British settlements in India from 1600 to 1720. So let us try to answer this through memory. Trace the development of judicial administration. So initially the East India Company was established for trading and not for administering justice. The British East India Company was established through Charter of 1600 by Queen Elizabeth I, and under this charter, the company was granted a lease of 15 years to exclusively deal with the East Indies. The company acquired territories in India for establishing their settlements or their colonies. Initially, it acquired Surat, four cities. In 4 cities, trading factories were set up. Surat, Bombay, Madras and Calcutta. Starting with Surat, where the first factory was set up, there the administration of justice was done by the Mughal, who was also known as the Subedar of Surat, Subedar of Surat, and the company administered, resolved the disputes among the Englishmen. Whereas in Bombay, Madras and Calcutta, where Bombay was acquired by, was handed over by King George I as a dowry. In Bombay's territory, the administration of justice was done by governor and council. Here too, it handled both the civil and criminal disputes, but through English laws. But the Indians were administered justice through their own local customs and rules. Whereas in Madras, which was acquired, Fort Saint let us just revise this. So in Surat, the first factory was set up. The local Mughal or governor retained judicial control. The English disputes were handled by the company agents. Whereas in Madras, Madras was granted by local ruler to the company. The governor and council exercised judicial and executive power. They acted as judges in both civil and criminal matters among English residents, and native inhabitants were governed by their own laws and customs. So the word is native inhabitants. Bombay, which was acquired by England as a part of Catherine of Braganza's dowry when she married Charles II of England in 1661. In 1668, Charles II leased Bombay to East India Company for £10 per annum. The governor and council in Bombay were authorized to make laws, administer justice and appoint judges. In Calcutta, Calcutta was acquired by 1698. Governor and council was appointed for Fort William. The name of the fort is Fort William in Calcutta. To administer justice, the administration of justice was rudimentary. Company officials decided disputes informally. This is how the justice was administered during the British settlements in India from 1600 to 1726. Discuss the powers of East India Company under the Charter of 1661 and their implication on judicial administration. What is the power of the East India Company under Charter of 1661 and their implication on judicial administration? Okay, Charter of 1661. So this charter was issued by Charles II. This was a turning point in the company's governance. It granted the company the power to make law, administer justice and impose punishment on English subjects residing in India. The governor and council in each settlement could try both civil and criminal cases. At that time, the courts in practice were the governor and council, which was the main judicial authority. Minor officers handled petty cases and appeals could be made to the Court of Directors in England. Compare the administration of justice in Madras, Bombay and Calcutta prior to 1720. So in Madras, the governor and council administered justice among the, let us go through this charter again, once again. In Madras, Madras was granted by local ruler to the company. The governor and council exercised judicial and executive powers. They acted as judges in both civil and criminal matters among English residents, and native inhabitants were governed by their own laws and customs. In Bombay, which was acquired by England as a part of Catherine of Braganza's dowry when she married Charles II of England in 1661, in 1668, that is after 7 years, Charles II leased Bombay to the East India Company for £10 per annum. The governor and council in Bombay were authorized to make laws, administer justice, and appoint judges. Whereas in Calcutta, from 1690 onwards, the first factory was set up in 1690, and by 1698, Calcutta was officially acquired. A governor and council was appointed for Fort William there. The administration of justice was rudimentary, that is, company officials decided disputes informally. So this is what was how the justice was administered in Madras before 1720. So this question was specific to Madras before 1720. What were the main problems in the judicial system during this period? So during this period, the main problems in the judicial system during this period was there was arbitrariness in the way the justice was delivered. There was the Indians were denied justice or felt lack thereof. Also, let us look at all the four problems. There was no separation of powers. The justice was arbitrary. There was no lack of uniformity in how justice was delivered, and Indians often received unequal or minimal justice under the company's rules. Critically analyze how the judicial system between 1600 and 1726 prepared the ground for later reforms. The chaos and the inconsistency across settlements led to the Crown's intervention. The Charter of 1726 was issued by King George I to establish mayors' courts in Bombay, Madras and Calcutta and create a more uniform and formal judicial system. This marked the end of the unregulated phase, 1600 to 1726, and the beginning of the structured colonial courts in India. Let us do the fill in the blanks. East India Company was established in the year 1600 by Queen Elizabeth I. The Charter of Dash granted the company power to make laws and administer justice. The Charter of 1661 or 1662, was it? Charter of 1661 granted the company power to make laws and administer justice. Bombay was transferred to the company by King George II in the year 1680, I suppose. In 1668, Charles II leased Bombay to the East India Company. The first English factory in India was established at Surat. The Charter of 1726 was issued by King George I. The Charter of 1726 was issued by King George I. Let's go with true and false. The East India Company was granted judicial powers over Indian subjects in 1600s. This is false. The Charter of 1661 empowered the company to administer justice to English subjects. This is true. The governor and council had both executive and judicial powers. Correct. The governor and council had both executive and judicial powers. There was no separation of powers. The mayor's courts were established by the Charter of 1661. This is false. The mayor's courts were established by the Charter of 1726. The period between 1600 and 1726 is considered the era of unregulated judicial administration. This answer is true. It is indeed, this era is considered as unregulated judicial administration. So this period illustrates the origins of the Indian legal system under colonial rule. It shows the transition from trading governance to territorial administration, lays the foundation for judicial reform and establishment of formal courts, that is from 1726 onwards. It demonstrates the early imbalance and arbitrariness that led to later principles like rule of law and independence of judiciary. It highlights the evolution of the dual judicial system, that is English law for the company's servants and native law for Indians. Next we will cover establishment of mayor's courts of 1726.